Welcome, everyone, to today's session of How to Manage Your Finances During Cancer, Protecting Yourself from Financial Disaster If You Are Unable to Manage Your Affairs, led by Certified Financial Planner Rick Fingerman. This program is hosted by the Blum Resource Center. Over at the Blum, we are grateful to Rick and his team for this continued partnership. The recording of this session will be posted on our Blum YouTube playlist and our Blum Digital Resource Center. For those of you watching live, if you have any questions related to today's program, please feel free to utilize the chat feature throughout the session. At the end of the session, your questions in the chat will be used to moderate a Q&A. If you have any other questions or would like more information about resources and programs offered through the Blum, please visit our website at www.dana-farber.org/resource center or email us at blum_center@dfci.harvard.edu. Thank you all for joining us. I will now pass the workshop over to Rick.
Thanks, Becca. Welcome, everyone, to another session on how to manage finances during cancer treatment. So if I can see how to advance the slide, I will do that. Here we go. So the title of this one is Protecting Yourself from Financial Disaster If You're Unable to Manage Your Affairs. So things can happen in life, and we want to make sure that you have a plan in place so that you can do that. So this is a picture of a much younger me holding that little trophy behind the check. This was an award that the Financial Planning Association won for the work that we do here at Dana-Farber, and we donated the $5,000 to the Patient Assistance Fund. And we continue to do that. Any awards that we win go to the Patient Assistance Fund. So that's my goal. Just a quick disclaimer, the information today, I'm not going to read this, but it's really just educational. It's not meant specific legal or medical or financial advice in any way. However, if you do have a specific question, on the last slide is my contact info. And for anyone attending or seeing this, I'm happy to speak with you one-on-one and answer any questions that you might have. So the question is, are there ways to protect yourself from financial disaster if you're unable to manage your affairs? And the answer is yes, there are. So generally, this comes down to having the proper estate planning documents. And you've probably heard of things called a will, maybe a healthcare proxy, a durable power of attorney, a living will, and a trust. And we'll just walk through these one by one and kind of address each one and how they work. So a will allows one to distribute property that you own after you pass away. A will can name a person to administer your affairs. This is called a personal representative now. It used to be called an executor or an executrix, and sometimes those terms are interchangeable. You can name specific items such as jewelry or a car or tools. So maybe you want to leave something to your granddaughter. You can specifically say that in a will. A will is pretty much the only document that can name a guardian for minor children. So if you have kids that are under 18, you can name a guardian to take care of them if you were no longer able to. And it allows the naming of gifts to certain individuals or charities. So you could say, I leave $5,000 to Dana-Farber, for an example, in your will. It can help avoid inheritance disputes. Sometimes somebody leaves somebody out of their will or their estate plan because they just don't want to acknowledge them. So they might have, it could be like a sibling that they haven't talked to in 30 years. It's a good idea to actually name that person in the will. Again, I'm not an attorney. This isn't legal advice, so you'd want to check this with an attorney, but it'd be good to leave them something or at least mention them so they're not forgotten in their eyes and thinking it's a mistake. So that's something that's important to do. It can include special instructions for your pets. So people that have pets, they want to make sure that they're well taken care of. You can do that in your will. And a will can be subject to probate. We can talk a little bit more about this, but probate is just, it's a legal system that validates, your estate to make sure that your bills are paid and things like that. And if you own things individually in your name alone, those assets go through that probate process. And some people have heard we want to, avoid probate at all costs. It's the most evil thing in the world. And it can take time. It could take 9 months or a year to settle an estate that goes through probate. There can be additional expenses to probate an estate because there are costs, core costs and attorney costs for that. So that's something to think about. If we move on to a healthcare proxy, that allows you to name an individual or more than one person to make healthcare decisions if you're unable to communicate them. So this is not for end of life decisions, but for an example, it might be a certain procedure is recommended, but you can't speak to that because you're either in a coma or you just can't communicate. then this person that you name as a healthcare proxy can make those decisions. And it is good to name more than one person in case that person isn't available at that time. So that's something that's a good thing to have. The Drupal power of attorney is a little bit different. It's similar to a healthcare proxy, but it's not about your health or medical. It's all about finances. So you would name somebody, an individual again, or more than one, to make financial decisions if you're unable to communicate those. And a Drupal power of attorney can be really, broad, or it can be very limiting. And we'll take a look at some examples there. So the Drupal power of attorney, or DPOA, can be very general, or it can be specific. You decide. So you can make that decision. You could say, I give my power of attorney the right to do anything, or all I want them to do is be able to pay my bills. So it can be very limiting, or it can be very broad-based. And that word durable just means that it stays in effect if you become incapacitated and you can't communicate. So you definitely want to pick someone that you trust and that will make these decisions for you if that ever happens. So that Drupal power of attorney allows one to act on your behalf, as I mentioned. It can allow you to pay bills. It can allow one to sell or refinance your house. You can file taxes. It can allow that person to make gifts. And it also can allow that person to file for government benefits for you. So let's say it's deemed you should go on Social Security disability. A Drupal power of attorney, if it's set up correctly, can do things like that as well. So it's really a powerful document to have and really important. And you can revoke it at any time if you're able to. So you can change the power of attorney, or just get rid of it altogether. A living will is that written document that makes your wishes known pertaining to life support. And again, people have different views on this. Some people want to be on life support if something happens, other people don't. But just to give you an example, some language could be something like, if I suffer an incurable, irreversible illness, disease, or condition, and my attending physician determines that my condition is terminal, I direct that life-sustaining measures would serve only to prolong my dying to be withheld or discontinued. So again, you can say anything you want. This is another document that is really important to have too. On to trust. Now, we could spend probably 2 hours talking about trust, but basically I'll cut it down. There's revocable trust and there's irrevocable trust. Revocable just means you can change it, and irrevocable means it's really hard to change it. It might be possible, but pretty much you can't change it. So if we look at revocable first, it allows the grantor, the creator, that would be you, to control the assets in the trust. So example, the distributions to children. And unlike a will, it can avoid probate if it's set up properly. We've talked a little bit more about that. It can be modified or revoked at any time, but it doesn't protect assets from creditors. So if you have a revocable trust, even if it's funded properly and set up properly, and you had a car accident, that person in theory could still sue you and access the assets in that revocable trust. So something to be mindful of. Irrevocable trusts offer more protection, but you want to be really careful doing those because they're irrevocable. So here, the grantor or the creator, that's again you, loses control of those assets generally. Unlike a will, it can also avoid probate if it's set up properly. It can't be modified or revoked at any time, not easily anyway. And it can offer protection from creditors because it's irrevocable and you can't get to those assets, then someone that's suing you potentially couldn't get to them either. So that has some added features there, but it can also help you become eligible for Medicaid or Mass Health. If one had to go in a nursing home and you set up an irrevocable trust at least 5 years prior to needing help, those assets, if done correctly, could be protected from a nursing home lien. So that's something else to consider. Now, there are some other ways to protect yourself that have nothing to do with an attorney or legal documents. And I want to just mention these because these are equally as important, because even if you have the best estate plan with all those documents we just mentioned, if you don't do some other things, it could kind of blow things up. So, and that's beneficiary designations. You want to make sure that the beneficiary designations on your accounts match your wishes in your estate plan. So, and the reason is because they can supersede one's wishes in their will. And I think I have an example here. Yep. So Mary is divorced, has 2 children, Felicity and Miguel. She would like to leave them her IRA worth $400,000 when she dies. And her will states, I leave my IRA equally to my 2 children. Well, that in itself should get the job done. However, After she passed away, Felicity and Miguel do not receive the IRA assets. Why? Well, it's because she didn't rename the beneficiary on her IRA, which named her sister many years ago. So because the beneficiary designations on accounts can supersede one's wishes in their will, you really have to look at all these beneficiary designations. And I've been doing financial planning for 30 years. I've had people say to me, no, I know for a fact this is my son is on this account, or my niece is on this account, or my husband's on this account. And when we've looked at it more closely, we found out that that was not the case. So really want to look at these. For our clients, we look at this pretty much on a yearly basis. We ask this question, has anything changed? And let's make sure that these are correct. So, because if you don't do this, your estate plan can have devastating results. So things you want to review is any type of retirement plan. So that includes IRAs or Roth IRAs, 401ks, 403bs, 457s, any type of retirement plan, whether you established it yourself or whether you have it through work. All of those have the provision to name a beneficiary. Sometimes we've looked at these accounts for people and there's not a beneficiary named at all, not the wrong one, but just doesn't have one. In that case, what the law says is if you pass away, it's left to your estate. And if it's left to your estate, it means it's guaranteed to go through that probate process, unless it's a very small amount of money. And then it could take 9 months, a year, or whatever, to get it to the right people. So for an example, if someone's married, they pass away, they don't have a beneficiary named, it wouldn't automatically go to their spouse. It would, unless they were named specifically as that beneficiary, it would go through the estate and then ultimately it would pass to that spouse because they're next in line for this purpose. The other thing to look at is any type of life insurance or annuities. And life insurance could be something that you bought on yourself. You bought a life insurance policy. And when you bought it, most likely, if the agent was doing their job, asked who you wanted to be named as beneficiary. And also the same applies to annuities. So if you buy an annuity, that also has a beneficiary designation. And whether you do this through work or through your own, they all have that same beneficiary. There are two types of beneficiaries. There's primary beneficiaries. That means if something happened to you today, for example, that money would go to that primary beneficiary. So if we say, for example, Mary named her sister 100% primary beneficiary, 100% of that money would go to her sister. Or she could have named her two sisters, Mary and Susan, and 50% goes to each, for an example, or whatever percentage she designates. But there's also something called the contingent beneficiary, and that comes into place if the primary beneficiary is no longer living. So if the primary beneficiary either died the same time you did or predeceased you, but you never renamed it, and you had a contingent beneficiary named, then that asset, the IRA or 401k or the life insurance, would go to that contingent beneficiary. So again, these primary and contingent beneficiaries are really important to have. And even if you think you're all set, it's worth looking at because you just never know. Okay, so I'm probably just redundant here, but make sure that every retirement account, life policy, annuity that you own names the correct beneficiary or beneficiaries. You can add something called the transfer on death, or TOD, or a payable on death, a POD, on all individually owned non-retirement type accounts. So let's just say, for example, you had $50,000 at the bank, and it's just in your name alone in an individual account. That, in theory, could go through probate if you passed away. But if you named your sister on that account as a payable on death or a transfer on death, that money would go directly to her upon your passing. One thing to keep in mind is if you want someone to have control of that account to pay bills or do something, and you don't have a durable power of attorney to do that, then that person cannot access that account until you pass away. So again, Mary has $50,000 at Citizens Bank. She names her sister 100% beneficiary on a POD or a TOD, but she's in the hospital and she just needs her mortgage to be paid. Well, her sister can't access that account because she only gets that when she passes away, unless she has a durable power of attorney, which she names her on there, and then she could go to the bank with that durable power of attorney and she could access that account. Okay, and here I'm saying don't just do a primary beneficiary, also consider adding a contingent beneficiary to all accounts, because just if something happens to that person and it doesn't get changed, then at least it goes to the contingent beneficiary. Well, I think we're wrapping up here. So the final word in estate planning is make sure your wishes are carried out you want to put your plan in place today or tomorrow. And those that are patients of the Dana-Farber Cancer Institute may be eligible to get an estate plan at no cost. So we have estate planning attorneys that are very willing to put a plan in place, all these documents that we talked about. A little bit about that program, which I skipped over in the beginning. Back in 2008, trustee of Dana-Farber had this idea: what if we could offer pro bono financial help to patients of Dana-Farber? And we did a kind of like a just little test run back then in 2008. I worked with a couple of people. It was overwhelmingly successful, and we ramped it out, and now we're up over 630 families I think we've worked with. So if you have some concerns, whether it's on, debt or estate planning or just paying your bills or whatever it might be, you can reach out to someone at Dana-Farber, either your social worker or Becca can probably steer you to the right person, and you can get part of this program at no cost to you and potentially get an estate plan as well, which is really important. Yep, and this is my offer to you. So just a complimentary call to me if you have any personal questions. Happy to help. Ideally, it's best if you could write down my email address. That's probably the best way to contact me, because I'm not always by the phone, but I will get back to you that day or the next day if you shoot me an email. And I think that is it. So if we have any questions, we can look at those.
All right. Thank you
And we're
so
back.
much, Rick. This was a really
Sure.
great presentation.
Estate planning in 10 minutes.
There you go.
I don't know how long it is actually. No, 17 minutes.
It doesn't look like we have any questions.
Okay.
Oh, yeah, nope, no questions. All right. Well, thank you again. You'll be able to find this recording on our Blum YouTube playlist, as well as our Blum Digital Resource Center. And then you will also be able to find some more programs and resources on there as well. So have a great rest of your day.
Thank you.